Welcome to Ground Rules, Employment Law Over Your Coffee Break. My name's Pam Howland, and I'm here today with Jennifer Walrath and Doug Plass. We are all attorneys at Idaho Employment Lawyers, and we're here today talking about the Pregnant Workers Fairness Act. We wanted to spend some time digging into this act and telling you a little bit about it because it's relatively new. And we have been watching as it develops and unfolds. And we think there are a lot of employers out there who maybe aren't spending as much time as they should really thinking about what this act is and what it requires. And on top of that, I think the name is very misleading. So the Pregnant Workers Fairness Act. We're going to talk about the scope. We're going to talk about some nuanced issues that make this act stand out from other obligations that employers might have. But don't be fooled by the name, because this act is much bigger and it applies to more than just pregnant workers. So we're going to tell you more about that. But first, we want to give you a really high-level overview of what this act is. So this act went into place in 2023. So not exactly brand new, but relatively new in the big scheme of things. And we know that in 2024, as we were seeing all of these new employment laws roll out, that there were some EEOC regulations that came out related to this act. And from our perspective, that was very important. Why? Because when you have a big federal statute like this, there's a lot of room for interpretation and a lot of questions as to what the act means and how it's going to be interpreted and enforced. That EEOC guidance that came out last summer shed a lot of light on that. And I know there's arguments out there that maybe the EEOC agency guidance may not have as much punch and may not have the level of deference afforded to it that it has in past eras and in times prior to this. But at the end of the day, what you've got is just one giant set of guidance that really digs in, looks at the act, and gives very practical guidance to employers on what that act does and does not mean. So as of last summer, we had a little more clarity on what that act is going to mean for employers, and we want to talk to you about that. On top of that, we know that the EEOC indicated last year that enforcement of the Pregnant Workers Fairness Act was a priority for it. And as we watch the EEOC news releases, we have seen that the EEOC is going after some employers for violations of the Pregnant Workers Fairness Act, and you should be aware of that. You should also, if you haven't yet, you should subscribe to these EEOC updates. You can get on the EEOC website, you can get their updates, and then you can follow along like we do to see what the EEOC is up to and what type of actions and lawsuits it's pursuing against employers. So a couple of fairly recent things I've seen come across on the EEOC updates. There was a January 16th, 2025 update that came out talking about how the EEOC was investigating a charge of pregnancy discrimination filed by a driver. So I would say that's probably a truck driver. This did not occur in Idaho. It was in the Midwest, more like in Illinois. And what's interesting to me about that update is it's talking about how the EEOC was investigating this claim of pregnancy discrimination. And it was talking about the way the EEOC was going about doing that. And the actual name that they gave to this press release is the EEOC files the agency's first subpoena enforcement action under the Pregnant Workers Fairness Act. So, that sounds like a lot of jargon, right? Like a lot of legal jargon, like what's a subpoena enforcement action? And the big takeaway on this is that in order to investigate this claim, the EEOC went to the company and it sought not just information about the employee who brought the pregnancy discrimination claim, but it also sought information about all employees who worked for that company and who worked in Illinois, Wisconsin, Minnesota, Iowa, South Dakota, and North Dakota employees of that company, information about any employees in that 5-state area who had requested accommodations for pregnancy-related restrictions. If you're lawyers like we are, that's a big deal, because imagine if you're that employer and suddenly you've got a request for information about many, many employees, not just the one bringing the charge of discrimination, but a whole bunch of others too. That opens up a lot of questions. So that's one example of what we're seeing from the EEOC. We also saw a release that came out in December indicating that the EEOC had released information to healthcare providers, basically telling healthcare providers what the Pregnant Workers Fairness Act was and how they could help their patients get protections under it. Check that out if you want. There's now guidance for healthcare providers out there, telling them what type of documentation they should provide under the Pregnant Workers Fairness Act, and really giving a rundown of what that act entitles the patients to who are pregnant. So check that out too. So Jen and Doug are here with me, and I've asked them to touch on a few of the issues related to the Pregnant Workers Fairness Act. And I was going to start by having Jennifer talk a little bit about the breadth of the Pregnant Workers Fairness Act, you know, the scope of it, and why it's about a lot more than just pregnant women.
Yeah, so as Pam mentioned, the name is a little bit misleading, right? Because it does go beyond simply workers who are currently pregnant. So a little bit of legal jargon. What the PWFA does is requires reasonable accommodations to an employee or an applicant. So it could also be for folks who are applying to work for you if you're an employer, and to accommodate known limitations related to, affected by, or arising out of a pregnancy, childbirth, or related medical condition, unless the accommodation will cause an undue hardship. And I will say, for some of you, that might sound a little familiar because it sounds like the ADA, the Americans with Disabilities Act. But this really is a little different. There can be some overlap. And if you look at this, right, so the words I was saying related to, affected by, or arising out of pregnancy, childbirth, or related medical condition, you know, pregnancy's in there, but there is the actual childbirth. And then related medical conditions gets very broad, right? So if you are experiencing something in terms of a health condition, and it is tied in some way to a pregnancy or having had a child, so childbirth, that is covered under the Pregnant Workers Fairness Act. And that can be, I think, really surprising to a lot of employers, and is kind of the place where you might see some overlap with the ADA, but it could even be maybe after childbirth if, in this case, probably a mother is having, say, mental health challenges following having a child. That is something that the PWFA may well cover, and where the employer is obligated to work with that worker to find an accommodation. Also, if you have a pregnant worker who just had a child, and maybe they had a pre-existing medical condition that was aggravated during the course of the pregnancy or following childbirth, that also is something that could be covered by the PWFA. I think some of the other surprising things that can be covered are things that are medical issues that come up prior to when a worker is pregnant. It could even cover things like birth control. If a worker is trying to get pregnant, maybe going through an IVF process, and they need an accommodation to, say, attend appointments, those are the kinds of things that also would be covered by the PWFA. Even things, again, someone who has just become pregnant, morning sickness, kind of a common thing. But just a very long list of potential conditions that are covered by the PWFA. And the last thing I'll say on this is if you go and look at the EEOC regulation that was issued last year and look at the guidance that Pam mentioned earlier, there is a very long list of very specific things that the PWFA covers. But at the end, it very specifically says it's non-exhaustive, right? So there could be other things. And essentially, I think that if you're an employer and you are aware that a worker is, trying to get pregnant, is pregnant, recently had a child, it is time to look at the PWFA, and if that worker needs something to help, stay in the workplace and do their job, you may need to look at whether or not an accommodation is required under this law.
Yeah, so the scope is broad, as you can tell by that. And again, much bigger than just pregnant employees. Jennifer was given that example of how it could aggravate a pre-existing condition. So think of one example of that, maybe if somebody suffers depression, they get pregnant, maybe they have postpartum depression. You could have an employee subject to protections under the ADA, PWFA, possibly Title VII too. There can be a lot of overlap on the protections that apply to different employees with the addition of this act. And the scope includes public employers and private employers who have 15 or more employees. That's an interesting issue too, because we know here in Idaho, and I know other states have somewhat similar types of statutory constructs, but here in Idaho, we have the Idaho Human Rights Act that applies to 5 or more employees if you're an employer. The Pregnant Workers Fairness Act specifically says it applies to 15 or more. And that raised a question with us as to whether or not the Idaho Human Rights Act would cover the Pregnant Workers Fairness Act. In other words, if you have 5 or more employees, are you going to be subjected to the Pregnant Workers Fairness Act, kind of like you would be under the ADA? So we went to the Idaho Human Rights Commission. We asked Ben Ehrwicker, the director, and the answer to that appears to be for now that the Pregnant Workers Fairness Act is a little different. So it's not covered by the Idaho Human Rights Act. And it truly is a 15 or more employee kick in. So if you have 15 or more, you're covered by the Pregnant Workers Fairness Act. If you don't, you are not subjected to that. But again, don't forget, you still are going to have ADA issues there.
And the only thing I was going to add to is that, discrimination on the basis of sex does include discrimination against a pregnant worker. So there may not be coverage if you're only covered by state law for the accommodations piece of this under the PWFA, but I would say don't forget that you may still have obligations to pregnant workers under state law to not discriminate on the basis of sex.
Yeah, that's a good point. And we're going to turn it over to Doug to talk more about accommodations under the Pregnant Workers Fairness Act, because that really is the crux of this act, is providing accommodations.
Yeah, thanks, Pam. And before I do that, I just also wanted to note that we haven't said this yet, but it just applies to pregnant or potentially pregnant or formerly pregnant employees, but not their family members. So it's not like the Family Medical Leave Act or anything in that regard. So one thing the PWFA does that's different from the ADA is it says if there are these easy accommodations that the employer can grant, it should just do so and shouldn't require documentation or engage in any sort of lengthy process. So under the rule, these are called predictable assessments. And there are 4 listed under the rule, although there may be a few more that would fall into that category as well. So these are things like sitting for a job that requires standing for a job that requires sitting, making more frequent breaks to eat or drink, drinking or carrying water with you while you are working, and potentially more frequent rest or bathroom breaks. So these are things that, anyone who has any experience with pregnant people knows that they may need these sorts of things. What the regulations say is just go ahead and grant them. Don't ask for documentation. If somebody is obviously pregnant, help them out there. There may be some other accommodations that kind of fall into this category as well. For instance, if your uniforms or safety equipment don't fit because somebody's pregnant, well, the employer should just address the problem and either get uniforms that fit or allow the employee to use whatever clothing that they have. You may have to provide some minor modifications to the workstation or the use of a closer parking space or something like that. These are really simple things that the employer can do without going through a process of requesting documentation from the employee and kind of thinking as to whether or not these are any undue hardship for the business.
Yeah. And how about interim measures? Tell us a little bit about that, because to me, that's a big deal that is also a lot different than the 8.
Yeah. So when someone is requesting some sort of accommodation, what the PWFA says is that you shouldn't delay, right? You may have to just grant some interim accommodation while you go through the interactive process and while you decide if this is something that is reasonable and that isn't an undue hardship for the business. So these are things where there's some sudden onset of limitation that makes it unsafe or causes a risk to perform the normal tasks of the job. So, for instance, if someone has just been put on bed rest and they need to be either working from home or some unpaid leave, the employers say, okay, well, let's start with that. Go ahead, take time off while we work through this process. Another example would be somebody who has some bad morning sickness and is on a food production line. Well, obviously, you're not going to want that person on your food production line. So you're going to have to address that in the short term. We'll take you off the line, we'll have you do something else, or we'll give you some leave or whatever while we work through this process. There's kind of a limitless example of those sorts of things you could think of.
I was just going to put in a plug there that what that kind of means in practice potentially is that your supervisors really need to have a certain level of knowledge about this law. And I would say, we're big champions of supervisors, being trained generally. But I would say very much important with, kind of the ADA, but also now with the PWFA, because depending on how your business operates, the supervisor may well be the person who gets that request. HR may or may not be immediately available, and the supervisor may have to make the call on that interim accommodation more or less on the spot.
Right. And the thing that I think is a little different than the ADA here is that, under the ADA, there's this concern, well, if I grant this accommodation without working through the process, will I have in some way decided that this is not an undue hardship for the business? Here, the PWSA says the most important thing is trying to keep the employee working and protecting the health of the pregnancy. So go ahead, grant some accommodation. You're not really waiving anything by doing that. You're just trying to move on to the next step without creating any risks for safety or the health or otherwise.
And that is an important point that we want to really drive home, is that there are a lot of differences here between the ADA and the PWFA. I think we've all gotten used, hopefully everyone's gotten used to the concept of accommodations and what that means in the ADA context. And for us, we have a very specific protocol we follow when someone seeks an accommodation under the ADA. And that looks somewhat like, okay, you're going to sit down with them, you're going to engage in the interactive process, you're going to give them the ADA accommodation letter, and you're going to gather input from the healthcare provider so you can look at their essential functions, and they can tell you which essential functions are you having trouble performing, and you can analyze reasonable accommodations. Under the PWFA, the guidance says that's not necessarily the protocol you're going to follow here. And that's what Doug's point really drives home is, The EEOC guidance under the PWFA says, no, you're not going to do this big interactive process in some cases before you grant or deny an accommodation. And in a lot of ways, I guess, in the pregnancy context, it makes sense, right? Because time is of the essence. There could be life-threatening issues going on there. But that's a big difference between the ADA and the PWFA is the EEOC has gone so far as to say under the PWFA, these are the things that you need to just go ahead and grant, and you're not going to find a list like that under the ADA. That's a big difference. Also different is the level and the type of documentation that an employer can seek. And the guidance is very clear in that they don't want you using the same ADA accommodation letter or FMLA form that you're going to use when it comes to other types of statutes. They want this done in a way that doesn't require the same level of healthcare provider input in many situations. Now, I would say that there are going to be situations if there's an accommodation being requested that is going to be a big challenge and possibly an undue burden for the employer, where you might need to get that documentation from the healthcare provider too. And as I was saying when we first started, check out that guidance from the EEOC that came out in December, where they specifically tell healthcare providers what the scope of documentation is and isn't allowed. That can help you get pointed in the right direction. But the big takeaway is this looks different than the ADA. So don't just go into it thinking, hey, I've spent a lot of time thinking through the ADA process and we're going to follow it under the PWFA, because it's very different in some respects.
Yeah, I was going to throw in, I think, time will tell as this law gets implemented what this looks like. But I expect, and I think the EEOC has recognized that instances where requesting documentation will be appropriate will more likely be the related medical conditions, right? So a medical condition like I'm having morning sickness, not probably going to be in that camp, but post-childbirth, perhaps, if someone's experiencing lingering medical conditions, that dovetails more so with the ADA, and especially if it's a more significant accommodation that they need, then it may be appropriate to be asking for some level of documentation to figure out what really makes sense in terms of a reasonable accommodation.
And I think it's good to point out here that the other main difference between the PWFA and the ADA, and that is that under the ADA, employers have no obligation to excuse the essential functions of the job. And under the PWFA, it's a little, there is situations where the employer may have to excuse essential functions of the job on a temporary basis. And this kind of reflects the temporary nature of pregnancy, but also kind of this greater goal to try to keep pregnant people working while protecting pregnancies.
Yeah, and a couple of thoughts on that. What does that look like in terms of an example? Here's a little bit of a overview of what that could mean in the context of somewhat of a typical workplace. Is so say that you have a salesperson, they are required to meet a sales quota every week, and they have a pregnancy condition that's impacting their ability to do that. Under the ADA, employers are not typically required to excuse an essential function or even a quota like that. That's one thing under the ADA that's pretty clear is essential functions are not excused as part of the accommodation process. Under the PWFA, that could look very different. So if you have an employee who can't meet that essential function of the job, if it's on a temporary basis because of a medical condition caused by the pregnancy, that could mean the employer has to temporarily excuse the essential function. And that is very different than the ADA. Another thing we haven't really talked about, although we've touched on it, Doug was just mentioning that, is how the goal is to keep employees on the job working through their pregnancy. One thing the EEOC makes very clear is unpaid leave. So removing someone from the job is not what is contemplated under the PWFA. So, we talk in terms of the ADA of reasonable accommodation. There may be situations where a period of unpaid leave under the ADA is going to be an accommodation. Be very careful of that under the PWFA, because the EEOC says that is not what we have in mind when it comes to accommodations. We want employees on the job, not removed from the job. So one last thought on that essential function piece, just your friendly reminder, right? Like, how do you know what the essential functions are? That's where your job descriptions come in. Hopefully you've got those updated. Sometimes we have employers who say, well, why do I need job descriptions? This is your classic example. If you don't have job descriptions, if you have an ADA issue or a PWFA issue and no job description, it's going to be tough to maneuver through the process. So the best time to get those job descriptions in place and updated is now, before you have a problem brewing in the workplace and before you realize you're going to have challenges maneuvering through the process because you don't have what you need to do the analysis.
I think the only final thing I wanted to mention, and I think Doug already touched on this a little bit, is that as broad as the PWFA is, there are some things that are not covered, right? So it would not cover if someone else in your family is pregnant. So if your partner is the one having the child, that the PWFA does not apply to you. And also, after having a child, and I've had this come up a couple of times, if someone's having trouble with finding childcare, that is not something that the PWFA covers. So just to kind of be aware of that, right? Like bonding with the child, those kinds of things are actually not covered. It really is focused on the health and well-being of the pregnant worker and their pregnancy. That being said, there are a couple places where the coverage of the PWFA can extend beyond that pregnant worker. So just to be aware, there are provisions in there that protect against, retaliation or coercion against people exercising or trying to help someone exercise their rights under the PWFA. So for example, if there was a pregnant worker in the workplace and a coworker was trying to help her to get an accommodation under the PWFA, there would be prohibitions against any retaliation or mistreatment of the coworker trying to help because they were trying to help this individual exercise their rights. So, I won't spend a ton of time digging into that, but just be aware that that is probably the one place where the coverage of the PWFA can extend beyond the pregnant worker themselves.
So there you have it. There is the high-level overview of the Pregnant Workers Fairness Act. I love how Jennifer touched on how important supervisor training is. That's the question for you today. Are your supervisors aware of this law, and do they know enough to spot the issues under it? If a pregnant worker came to them and said, I'm pregnant, I'm struggling to do my job, and I need help, would they recognize that as an issue that's got its own set of rules and that they need to comply with? And you guys can't see me right now, but I'm holding up, Jennifer and Doug are laughing, I'm holding up our Law for Leaders book that came out in January. It's got Chapter 11, which covers the Pregnant Workers Fairness Act, among a whole bunch of other chapters aimed at helping employers know the key issues on the employment law front that they need to be familiar with in order to avoid workplace claims and lawsuits. We also have our Law for Leaders virtual and live training. We love to train. We love to come on site and do it. Obviously, live training is always best. But we do have virtual content on the Pregnant Workers Fairness Act, too. So check out our Law for Leaders website. And in the meantime, Stay tuned. Undoubtedly, in 2025, we're going to hear more about the Pregnant Workers Fairness Act. And as we learn more and see more cases coming through, we'll be sure to share those with you. So that's it for today. We'll see you next time on Ground Rules.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.